you like to approach? I believe it's sponsor only. And I'm unsure, unlike your colleague, I'm sure you won't take a lot of time presenting
Absolutely
your bill.
not.
We're trying to get Senator Kramer.
Look, and I should say at the outset, I only served in one committee, House of Delegates, this committee, so this is by far my favorite committee in this chamber. It's great. It is great to be here.
Great way to get
Mr.
started.
Chair? Yes, Mr. Chair. So Senate Bill 170's very narrowly crafted piece of legislation deals with energy projects that are 2 megawatts or greater and need a certificate of public convenience from the Maryland Public Service Commission. We're talking about big projects with major impacts on the community. So Senate Bill 170 is designed to do 2 very, very specific things. Straightforward. It helps us access our money from the Inflation Reduction Act, basically to help supercharge our clean power projects in the state. And secondly, put in place at the same time measures to ensure that Maryland's energy generation projects create quality family supporting jobs for Marylanders, as we've done on several occasions in the past few years in the energy space. So the bottom line is this, Mr. Chair. We're obviously in the middle of a shift in the nation transitioning to renewable energy. Large amounts of federal money are flowing to the states. We have $370 billion, repeat, $billion in the Inflation Reduction Act for clean energy over the next decade. So in November, the United States Treasury Department and IRS published guidance on the Inflation Reduction Act's prevailing wage and apprenticeship requirements, and taxpayers must meet the prevailing wage and apprenticeship requirements for facilities where construction begins on or after January 29, 2023 to be eligible for 30% tax credits for eligible clean energy projects. So the bill primarily attempts to align us with that criteria, enact measures which maximize the chances of us accessing those federal dollars, which I think should be one of the main goals this session for the General Assembly. So 170 simply requires that developers of these very large projects pay prevailing wage rates to the construction workforce, as we've done in other areas. Offshore wind, for example, when we passed that, originally we had labor standards. A few years ago, we had labor standards in a geothermal bill that Delegate Charkoudian championed. And so I just want to put that out there. So again, first and foremost, we're trying to put in place, align our laws with what's in place right now for accessing the Inflation Reduction Act money, which requires the payment of prevailing wage for large energy projects. Secondly, Mr. Chair, aside from that, from a public policy standpoint, I would say that as we shift to renewable energy and transition, we want to assure there are good paying jobs for all Marylanders, so it does make sense to establish workforce standards for these large energy projects, as I say, as we've done in the past. There also are some certification of compliance requirements for contractors and subcontractors, including certifying that the developers will or have properly classified the workers, specifically meaning that they're not classifying them as independent contractors when they should be classified as employees. Finally, Mr. Chair, I'd note that the provisions of this bill and the payment of prevailing wage, among other things, we be joining Illinois, Connecticut, New Jersey, Oregon, Washington, Minnesota, New York, have already passed laws just like this, in part to try to get access to those federal dollars in the Inflation Reduction Act for large energy projects. That's in effect what the bill does, nothing more, nothing less, and I'd certainly be happy to take any questions from any member of the committee. Thank you.
Thanks, sir. I see one question, but before I get to Delegate Harrison, I just want to make sure for points of clarification, because we've discussed in this committee multiple times about labor standards, and especially in the private industry, but it's your testimony today that this is done to help us. These labor standards are also required to help these developers get as much IRA money as possible, correct?
Absolutely.
So this isn't something we're just doing willy-nilly or the beginning of what they say, the camel's nose under the tent as far as labor in private industry. This has more to do with accessing, forcing for all intents and purposes, these developers to go after as much federal funds as possible to save our ratepayers, correct?
Absolutely. That's really the main point of the bill, is to align us with what the IRS Treasury Department guidance from November was, which required paying of prevailing wage, and so this aligns us with those criteria. So I think that's probably first and foremost the genesis of the bill.
And I think, as you know, a lot of times people come in and they say, well, yeah, well, you did it last year for this, but that's not really a cogent argument for this bill, because this bill is specifically to make sure that they can capture as much of that IRA money as possible. So
Absolutely, yes.
thank you very much. I believe we have one question. Delegate Harrison?
Thank you. I realize that this is particularly about the required labor standards, but my question is and always will be, is there minority MBE equity, not participation, but equity?
Sure. Just to be clear, the bill came out of the Senate Finance Committee, of which I don't serve. I'm in another committee. I'm sure, I don't know if this came up with Senator Hayes, Ellis, et cetera. One thing I would say is, and the chair knows this from our cannabis cross-file, when you're dealing with that, you've got to be careful with the constitutional parameters. And if there is, and I don't, in terms of diversity studies and all the right. So long as the Attorney General, I think somebody had mentioned the possibility of inserting an MBE provision in here. So long as the Attorney General says it's constitutionally sound, then that's fine with me. I can't speak for the Senate Finance Committee when it goes back, but that's the key here. You can't just throw it in there. If you do, you run into potentially a constitutional issue. And again, we're dealing with it in other issues, cannabis and the like. But that said, if you can get some AG sign-off, that certainly could be added into this piece of legislation.
Okay, I'm always going to ask that just for the record.
Sure.
And I also want to say that, and to address that issue, we understand that we always try to do the MBE work, and we always hear that first thing. We hear the diversity study, which is keywords to most of us that we ain't getting nothing. Yeah. So, but I will say there is something in Maryland called DBEs, and that's something that I've been exploring with this wind bill and this as well, and getting some language captured so we can start, because many of our MBEs are also DBEs, but that is a race-neutral appointment. That's something that we do with the feds when it comes to the Department of Transportation, which is also the same people that certify our MBEs. So we are going to be trying to take another route so we don't always have to deal with those diversity studies. So I appreciate your question. I have quite a few more questions now. Damn it. All right, we're going to go to Delegate Weigel.
Thank you, Mr. Chairman. Just a quick question. Does the bill mandate a prevailing wage even if those federal dollars aren't used?
Well, first of all, the bill's designed to get the federal dollars. It doesn't speak to if at the end of the day our energy developers don't get that 30% investment tax credit money. So this is a bit preemptive, because these are, I make this point, the $370 billion flown is, some of it's formulaic based on grants, but a lot of it's competitive. So we've been told, and the IRS and Treasury have said, those states that put in place some of the criteria that are called for in the guidance are going to be the states more likely to get the money. So this is where this is coming from. As to whether if we don't end up getting that, or our developers, that, the bill's silent on that. This is really on the front end, trying to best position our state to access that money.
So if I had a project and I didn't get the money, I applied, I didn't get it, I'd still be subject to the
You would.
prevailing
The bill
wage.
does put this into law.
All right, thank you.
For the large energy projects, 2 megawatts or larger, these are the big, big projects.
Senator Feldman, I was curious, the 2 megawatts or larger that's named in the bill, does the Inflation Reduction Act specify 2 megawatts or larger, or does it just say large?
No, actually, they're at 1 megawatt, and I think the 2 megawatts was set up to actually just, again, get to the much bigger projects. The prevailing wage rate for smaller project, 1 megawatt, which is what is in the IRA, that's really a small project. So the intent here is we're talking about major community impacts, more apprenticeships, more money into local economy, but for the big projects. So Inflation Reduction Act talks about 1 megawatt. It's my recollection. This is making it for the larger projects.
Thanks. Does the bill not apply to wind?
The offshore wind bills from 2013 largely dealt with offshore wind. So one of the reasons that's not part of this bill is because that was dealt with back in the 2013 and 2019 bills. So offshore wind is not part of this. This is for, largely a lot of big solar projects and things of that nature.
Got it. Thank you.
Yeah.
Favorite senator. Great
Yes.
to see you.
Two of you sitting right next to each other. Like two
Great
district-
bill. Sounds like a very smart bill that helps us leverage federal dollars. Thank you for introducing that. So I'm wondering, when you said at the beginning that we are your favorite committee, you didn't provide any reason. Could it be because Delegate Fraser Hidalgo and I happen to be here?
Absolutely, 100% that is the case. Yes, my favorite two delegates, and yes, 100%.
Yeah, I'm done. I'm good.
Thank you, Mr. Chair. I just wanted to clarify, you've said some really important things about positioning the state, but I wanted to just ask you to expand on one other piece, which is any individual developer who is not paying prevailing wage would actually get the tax credit, but only a 6% or a 10% instead of a 30%.
Right.
And if our goal is to have these done in our state with a maximum amount of money, us putting this into law will mean that they will automatically be eligible for the maximum amount of money. I just feel like that's the other piece of what you were saying to Delegate Weigel about
I agree.
why
So-
we're insisting on it. So if
So
you would say more
if we're
about
going to
that.
get federal money, we want to max out. We want to really leverage it. That 30% investment tax credit, and there's other monies involved, not be stuck in a 6% category or that other states who are not passing laws like this are going to stuck with. Gives us a major competitive advantage vis-a-vis some of our neighbors. So I appreciate that point. Excellent
you.
point.
Thank you, Mr. Chair.
Seeing no further questions, I believe that concludes this bill hearing. Senator, thank you very much.
Thank you, sir.
Have a good day. Next, I believe we have, I know that Senator Griffith is running her committee, so I believe we have the Madam Secretary. Are you going to be on her behalf? Can you please come on up? This is Senate Bill 928.
Thank you, Mr. Chair. Kathleen Borain on behalf of the Maryland Insurance Administration. So you might recall that when I met with you all earlier this year, just to give you a preview of the MIA, I mentioned that from time to time I would come in front of you and ask you to pass legislation that is an accreditation standard, so something that's coming out of the National Association of Insurance Commissioners that deals with the solvency of insurance companies. This is one of those bills. So this is a pretty technical clarifying amendment to legislation that y'all passed in 2020 in response to a treaty entered into by the federal government with the United Kingdom and with the EU. So essentially, you may recall us talking about the fact that when insurance companies, we are responsible to make sure that insurance companies stay solvent. So we watch their balance sheets very closely, and how much risk they can take depends on how much money they have in reserves and in the bank to pay claims. If an insurance company goes and gets reinsurance, that is, they transfer some of that risk off, then there is a formula that we can use that allows them to write more business. It's called credit for reinsurance. We give them credit for that reinsurance on their balance sheet. Now, when they buy that reinsurance from a U.S. company, right, then the rules are a certain way. But traditionally, when they would buy it from a company that was offshore, so outside of the U.S. where we are not their primary regulator, we would require that offshore insurance company to post 100% collateral. So for every dollar they were reinsuring, they would have to put $1 in a U.S. bank that could be called upon for the reinsurance. The United States in 2017 entered into treaties with the UK and with the EU so that certain of their insurance companies that met certain standards of EU and UK regulators would not have to post that collateral. Now, U.S. treaties trump state law. So the NAIC worked with the Federal Insurance Office to develop a model that would recognize that with respect to those companies specifically, there would not be that collateral requirement. So those treaties are referred to as covered agreements. The NAIC developed a model law, and the Maryland legislature passed that model law in 2017. But when we passed the model law in 2017, because Maryland law didn't exactly track the NAIC model, some of the language was changed. The Federal Insurance Office came back to me earlier this year and said, we really want some clarifying amendments. We want to really make sure that under no circumstances could the state insurance commissioner alter those covered agreements or refuse to honor those covered agreements. So that is the very highly technical change that you will see in the bill that makes it very clear that under no circumstance can the commissioner remove from the list of these reciprocal jurisdictions a jurisdiction that is a jurisdiction under a covered agreement. And we think the law already says that. We thought it was clear in our definitions, but we also had no objection to giving the Biden administration what it wanted in terms of that clarifying. amendment. So that, Mr. Chair, is the genesis of this legislation, and I'm happy to answer any questions.
I believe that was just about confusing enough to stop us from asking any questions.
You can see why I am popular
job.
at parties.
Outstanding. Thank you very much. I see no questions, so have a wonderful day.
Thank you.
Next, we have the Charles County Senators with Senate Bill 519. Is Hayes coming?
Hello, Chair Wilson, members of the committee, Vice Chair Crosby. I will confuse you even more so I can be out of here really quick. That's a joke, by the way. Yeah, thank you. I'm here to present Senator Arthur Ellis from Charles County, here to present Senate Bill 519. The other Charles County Senator being Senator Jackson from District 27. This bill, Senate Bill 516, clears up a loophole in the law in Charles County where unlicensed establishments have nothing to do with alcohol. They can have after-hour parties after they close their regular business, have people bring their own booze, and they cause a lot of mayhem some of the times. And the sheriff and law enforcement have no recourse in order to shut that business down and or their activity, which is now legal. Hopefully this bill will make it illegal so the sheriff's office can control this activity. I have several individuals here, including Judge Spencer from the sheriff's office, who will answer any detailed question you might have on the law and the current situations there. As such, Mr. Chair and committee, I ask for a favorable report on Senate Bill 519.
Thank you very much. And just for purposes of legislative intent, this bill, as we've discussed, this does not include individuals who throw parties at their private residence, correct?
Correct.
What about individuals that belong or create clubs? Like there are certain groups, there are certain areas or businesses that have a club that you join. Would this apply to them?
I'll turn that over to Judge Spencer to answer that specific.
Judge, if you understand my question, there are certain places you go, but you can only you have to be a member before you can come in, and they are BYOB because they don't get their own license or can't get their own license, whatever. Does this apply to them?
So good afternoon, Mr. Chairman. My name is Jerome Spencer. I'm the General Counsel of the Charles County Sheriff's Office. I'm here on behalf of Sheriff Troy Berry and the Charles County Sheriff's Office. So Delegate, thank you for that question. Current Maryland law deals with unlicensed establishments, and that's the words in our statute and most other county statutes. An establishment would be like a business. And I think Delegate Wilson, at an earlier meeting with the commissioners, you put it very well. If I'm a bakery next door to a nail salon, I'm entitled to know that's a nail salon, not a nightclub, which is kind of what happens from time to time. So it's certainly not intended to target what you described, Delegate Wilson.
It's the third time you called me delegate instead of chair, but I'm counting.
I apologize.
I'm literally just messing with you. Please go ahead. It was just a joke. You're fine, Jerome. Come on. You're totally fine. I'm sorry.
I'll get back at you, CT. But in the grand picture, Sergeant Girl is going to tell you some of the examples that deal with these issues. And it's not necessarily a matter of going after these businesses. It's a way to encourage the business to not engage that behavior. If it's a licensed establishment, there are rules you have to follow. They have to get trained about serving people who are under the influence, trained about identifying people under the age of 21. They have to buy alcohol from licensed wholesalers so we know it's safe alcohol. And there are incentives to encourage the behavior because they don't comply with the rules. Then the Board of License Commissioners, or liquor board, can impose fines upon them. So part of the goal is to encourage those who want to engage in alcohol activities to get the license. So they will have to understand the rules and follow the rules. And the goal from the Sheriff's Office is not to go around arresting people, is to educate, to mitigate is a word that Sheriff Berry uses a lot, to reduce the issues and hopefully provide some incentive, put another way, a disincentive to engage in this kind of behavior, which we don't currently have now. As it is now, we can respond to an individual occasion. If there's an assault, we can deal with that. If there's drug activity, we can deal with that. We're dealing with the individuals and not the establishment. We're trying to steer the behavior into a more peaceful and safe direction.
Well, I do see one question. Delegate Fisher.
Yeah, I'm only asking because we've had a similar issue in Calvary, and I was curious if and I think I understood what you said with respect to the bill, but in Calvert, we've had homes that are rented, and whether it be Airbnb or just they're rented for a period of time, and there are tickets that are sold outside the county or inside the county. People purchase tickets to come there, and the home is turned to a de facto club. They have a pool in the backyard, and they've, obviously they're selling alcohol, and so it's a business. So would the bill apply to that as well? I know it's Charles County only, but I'm just asking for our purposes.
So Doug, we actually deal with that issue sometimes in Charles County as well. And we work with our zoning people and the county government side to address those issues. We generally try to get involved in those issues before they occur, and again, educate and encourage compliance with rules. The law talks about unlicensed establishments. Now, that word establishment is not really defined anywhere. It's one of those things where we kind of know it when we see it. Gotcha. We know the nightclub is an establishment. We know the cigar shop is an establishment, the bakery. The private home that turns itself into a one-time public event is probably not an establishment. But to be fair, we don't really know that for sure. But that's not our focus with this bill, though.
Yeah, that's why I just want to make sure for those listening, and also for legislative intent, it is not the goal of the Charles County Sheriff's Department to be able to enter an individual's home because they suspect that it may be an establishment, correct?
Correct, absolutely.
Outstanding.
Yes, sir.
Delegate Howard.
What about the business, like the nail salon that wants to have people over in the evening, and they can bring their own wine and maybe display Max Factor products and these type of things? I mean, that's exactly what you're talking about.
Correct.
That would fall within the ambit, I think, of the
They're not
bill.
serving. I mean, they're not serving. They're not.
They're the problem.
But first, we're never going to know about that. We get the calls when there are people in the parking lot, there's fights breaking out, there's people drunk driving. So the sheriff's never going to respond to that. We're never going to know about that. And that's certainly not the focus of the attempt here. And certainly would not address the after hours, hey, employees, let's get together and have a couple beers after hours in our shop. It's to deal with the places that are open to the public for all practical purposes. And bring your own alcohol and let's have a great time, causing disruption and not following the rules that a licensed establishment would have to follow when they have alcohol.
They don't. The nail salon, the hair salon wouldn't be serving. They're not selling.
Right.
I mean, so there's law enforcement applicability outside of that. I mean, and if they're there because of they're there in the normal course of their duties, and they can break it up.
So what Charles County law says now, if you're an unlicensed establishment, you can't do a BYOB function and have live entertainment. Okay. So this bill, the focus of the bill is to strike live entertainment. So you become an unlicensed establishment serving alcohol. If this amendment is passed, then Charles County becomes similar to 10 other jurisdictions that have laws substantially the same as what we're trying to aim here. So it's a recurring, common ordinance in our counties to not allow unlicensed establishments to have a BYOB gathering.
How many incidents were there last year in Charles County related to this?
Well, so that's why I brought Sergeant Gilroy. She's our commander of a community policing unit. She can address some of the incidents we've had to deal with.
I don't have an exact number.
Ma'am, if you could bring that microphone over in front of you. There you go.
Yes, sir. I'm Sergeant Gilroy, Charles County Sheriff's Office. I am part of the community policing unit supervisor. I don't have an exact number for the establishment because we don't have a record of that type of call, but we have several calls to establishments for like disorderly, loud music, drinking, assault, domestic violence, drug activity, gang activity.
But then you're there in the normal course of policing activity.
Correct. So the alcohol units.
This gives you broader powers to be there, not in the normal course of policing activity.
So when we start to see a pattern at a specific establishment and we believe it's starting with talking with the people either arrested or other witnesses in the area, we believe there's an alcohol nexus to it. That's when my alcohol unit, they will address it and actually try to proactively address them, saying, hey, this is causing this activity inside your establishment around the area.
What does addressing it look like?
So they go in and they basically educate. They ask them to go try to apply for an alcohol license permit. They advise them what they're inviting in is what the activity that's occurring to make sure they're aware, because some of these establishments will allow an active party to occur and they're not actually there during those hours.
So at 2 o'clock in the morning, when 6 or 7 officers show up at one of these events, they're going to go in and educate?
So no, after the fact, normally that kind of behavior is usually, it's
What happens when they show up at one of these events if this law is passed? What happens? Walk me through that.
To the exact, I mean, like during the incident at 2 o'clock in the morning.
Or 12 o'clock at night?
So they're going to address the exact crime at that time.
What does address mean?
It depends on what the call is for. If it's disorderly,
It
sometimes
means
it's for.
arrest.
Yes, it could be arrest, or if there's no crime occurring and it's loud music, we get there, and the loud noise, we can't pinpoint who it's coming from, or they've already left, we're going to get in the area to disrupt that activity that could be crime, or
Who do you
try
arrest
to
when you
arrest.
go into an establishment that allows BYOB?
It
And
de-
they're just people in there, ladies in there getting their nails done,
in
and
that,
somebody's called the cops on them, because that's the world we live in today. And
In-
somebody's
in
called
that
the cops on people,
circumstance,
yeah.
nobody. If it's just called on for somebody drinking alcohol in the establishment of a nail salon.
That's exactly what this bill will allow you to do.
Correct. In the future, yes, it would allow us, I think in the owner aspect, to hold the owner accountable for allowing that activity.
What is accountable? What is
Accountable as in bringing them towards, requiring them to have a license to have alcohol service. If not, then it would be charged, have a criminal statute to charge.
But they would have a criminal statute. to
Yes,
charge.
now to be able to charge the owner, hold the owner accountable, or the main manager, whoever's actually responsible for that
So you would
business.
charge them, and then they would go get a license.
Or hopefully vice versa.
Well, we hope.
Yes.
But I don't like to make laws off hope, especially when we're dealing with penalty phases, people's civil violation rights and those type of things that come attached with these type of charges.
So currently,
Delegate, could I just interject here? This bill is not aimed to deal with the individual, say, client or the individual. It's strictly the establishment owner, keeping them responsible for the activities after business hours. So in your scenario, it does not deal with a nail salon client or anyone
Right, it
who
deals
goes in under this aspect. There are other aspects to the activity might be happening there, which other statutes will cover, assault or disorderly conduct.
Right.
But this bill is focused on a repeat offender establishment and that owner who create this scenario for 2 o'clock in the morning, neighbors are trying to sleep, and you have this untenable conduct. So it's strictly focused on the business owner,
Right, so
not the
arresting
individuals
the
who
business-
go
arrest the
to this
business
activity.
owner.
I'm sorry?
Arrest the business owner and then educate them and make them get a license.
Well, you know, the
Is there
sheriff's
a
office
portion
have
in the bill-
discretion.
Wait, guys,
sorry.
I don't want to get too back and forth.
Is it like bifurcated out, like on your first offense, this is what we're gonna do, on your second offense, this is what we're gonna do? On your
That's,
third
yeah, like
offense?
it's not in the, it's not in the bill, it's not in any county's current laws I'm aware of. But certainly, the sheriff's office approach is always to mitigate first and educate first. The criminal sanction is the last resort. If the behavior continues, it gives us the ability to say, look, if this continues, this is what can happen to you.
I'd love to see that in writing and in here.
Seth, I'll tell you, if you knew the bleeding heart hippies on my delegation, you'd know that they're not going to put a bill in that's going to allow the sheriff willy-nilly to arrest people.
I appreciate that and I believe you, but I'd like to see it in writing.
And-
We do many pieces of legislation where you say first offense this, second offense this, third offense this.
But,
And I would like to see that.
And we'll pull the other bills up because I used to enforce them when I was a prosecutor in Prince George's County. I understand the genesis of this bill as we have discussed with the county of individuals who put out advertisements, but it's BYOB, so there's nothing we can do, but you live next to them or your business is next to them and they keep doing it over and over again. There's no ramifications because once they find it, we call it a soft spot. My clients call it a soft spot. Once they find a place where the law's not being enforced, that's where they live. And what we don't want them to do is live in Charles County. That's why we put this in. We don't want, and so at the end of the day, and this is not, we're not arguing here. What I'm saying is I understand you're worried about the arrest or the overuse of this.
Absolutely.
But as he said, it's been done in 10 other counties to very moderate success. It's one more tool in the box. And I do understand, and believe me, again, if you had heard the discussion, we have gone through that repeatedly with Charles County delegation to make sure it cannot be abused. But when you weigh the options between citizens' consistent complaints versus a few individuals who know what they're doing but are allowed to get away with it, we tend to go with the citizens in addressing their complaints versus the ones that are breaking the law or found a loophole.
I just want to make sure that our business proprietors that are providing jobs and much needed revenue for these districts in the state, Mr. Chair, are, because eventually, like you said, this will go, And I'm worried about the policing in 2, 4, 5, or 10 years. I'm not
Sure.
and the direction and trajectory that these bills sometimes go. And I can absolutely see this being weaponized from business to business. I can absolutely see those type of things.
Well, what I will say is this, if we can't get our businesses to follow the laws, we'll have a hell of a time getting our citizens to follow the laws. So the goal is, again, the people that we license, the people that have made an agreement and a contract with our county, to have them act accordingly. If you say you're a barbershop, well, then that's what you are. If you're a nail salon, then that's what you are. You're not a club. And if you try to be a club, your neighbors deserve to know that they're not living or working beside a nail salon. They're working beside a club. So that, and again, we can't keep going back and forth, Seth. We can do this offline. I understand your point, but I also understand the point of this legislation. I helped draft it. So I want to make sure that we keep this moving. I understand your point, and we'll address it. I'll get you what you need.
Yeah, Mr. Chairman, could I add one thing, or you have?
There was no question, Senator, so.
There's no question? Okay.
Again, just for time, guys, I really appreciate what you're doing. Jerome, thank you for coming. Thank you guys for coming. Y'all have a good day.
Thank you, everybody.
All right, I believe we have, we don't usually do this. We usually make the people represent their own bills. The governor's not here, though, is he? That's all right.
I guess
Go
I'll
ahead,
have to do
Miles.
today. No, I am not Governor Moore. For all those who looks like. But my name is Miles Hicks. For the record, I serve as Deputy Legislative Officer for Governor Westmore. And again, Mr. Chairman and members of the committee, thank you for allowing me to speak today. I am here in favor of SB 555, the Fair Wage Act of 2023. As amended, this piece of legislation increases wages for approximately 163 Marylanders and lifts about 120 children in the states and their family out of poverty. There have been a few changes to this legislation since you guys heard it back in February that I would like to highlight. First is the implementation date has been pushed back to January 1st of 2024. Next, you will see indexing has been removed from the bill, along with the provisions that come along with that also include removing the Board of Public Works having the authority to temporarily suspend the increases. Of course, that is because of the indexing being removed from the bill. And then finally, you also see that those rate increases that were also tied to indexing have been removed as well. So again, our administration continues to support and believe that people should have the opportunity for a job they can raise their family on, wages that reflect the dignity of their work and the chance to create wealth for their families. So again, we urge a favorable report on SB 555 and look forward to continuing to work with this community. And happy to take any questions.
Yes, sir. First question, Delegate Pippy.
Thank you, Mr. Chairman, and thank you for coming in today, sir. As you indicated, the bill is not in the same posture as what we've seen before. So is it fair to say that Governor Moore supports the new version of this bill?
Yes, we do support this this version of the bill, and it is not the original bill that we brought to you guys last month.
So and just because there's a couple of amendments, so the indexing part has been taken out, and the administration is in support of the indexing portion being taken out?
Yes, we are still in support of the bill. We still do believe that there's a lot of Marylanders will be impacted by this bill. Our administration also still continues to support indexing, but this is still a bill that we can support.
Okay, thank you. Thank you, Mr. Chairman.
Thank you. I believe Delegate Harrison.
Thank you. I spoke with you previously about the DDA community and their reimbursement rates. Is that included in here? Will they be taken care of?
So the rates for providers, since indexing isn't taking place in the bill, the biggest concern for them was that
Talk a little bit more in your mic.
I'm sorry. But because indexing is not included in the bill, those automatic rate increases that were concerns from them has been removed.
So the DDA community is okay now?
I'd have to double check. I didn't check with them directly before this. We're very good friends. I'll make sure that I reach out to them. But I can't say yes on their behalf right now, but I can definitely check in with them.
Okay, thank you.
Delegate Pippy. Oh, I'm sorry, Delegate Aaron, sorry.
Thank you, Mr. Chair. You know, one of the things that caught my interest was we did remove the CPI. But when we did this bill originally, we talked about the minimum wage and what it would do, what it could do, and where we'll be in a couple of years. Well, we've accelerated that pace. Is there any thought in this bill to what's next? How long will this bill hold us off from having to re-up the minimum wage? Has there been thought put into accepting the CPI out?
So with that, I mean, we're talking about 15 minimum wage right now. We find that a lot of people in our state are still struggling to, again, get diapers for their babies, clothes on their kids' backs, food on their tables. This is a bill that's going to help raise them out of that. So right now, we are advocating for $15 minimum wage. As we see a need to increase that, we will continue to do that. I don't have a timeline with specific numbers for that, but this is what we are advocating for right now.
Okay, thank you. Thank you.
Point of clarification, Miles, I believe that he was talking about the dreaded issue we all have to deal with as legislators is give somebody something the very next year, it's like you never gave anything. And the very next year it goes, well, now it's $20 an hour. Let's get this started. And 15 is considered an abysmal number, even though it's the number that we agreed upon the year before. So I think that was the genesis of the good yet old delegate's question. And so just something to keep in mind as we move forward. You know, with when people give and when they come to the trough, at some point you would hope that they would be full, at least for a year or two. That's what I think the concern is.
Gotcha. No, and I hear I hear the issue that you guys.
I just know he might not have expressed it well sometimes. He tries. Just mess with you. You did a great job, Steve. I'm sorry. Next is Delegate Fisher. This is going to be good. Whatever it is.
Miles,
Yes,
my question is, the minimum number of employees that you have to have for this to apply is how many?
So this is going to accelerate the minimum wage for all employers.
No matter the size?
Correct.
Okay, so and that would start January of next year?
January 1st of 2024.
Okay. If that company, no matter its size, didn't make money the previous calendar year, and that this would still apply to that company even though they perhaps lost money?
I'm sorry, they're still in business if they. So you're saying they're operating at a loss? Yes, they would still have to increase the wages for their employees.
I mean, the only people that don't lose money are nonprofits because they don't have to make a profit.
Right,
but for-profit companies, what I'm referring to.
Yes, so even for nonprofits, this would apply to nonprofits as well.
But a for-profit company that lost money last year and filed its taxes with the state of Maryland and the comptroller's office and the federal government, the IRS, irrespective of losing money, they would still have to pay more in wages, which could potentially cause them to lay off or close.
Yes, so the minimum wage increases are going to go into effect for all business.
Got it. Thank you.
Very good job, Miles. I think you've answered everyone's questions. I believe that concludes your hearing. Thank you guys very much. We have our last hearing of the day, which is Senate Bill 828. Senator Hayes, come on up. Do you have a panel, sir?
Yes, sir. If you would indulge,
Please.
Mr. Chair, I believe I have Reagan Vaughn with me. Good afternoon, Mr. Chairman, Mr. Vice Chairman, members of Economic Matters Committee. Senator Antonio Hayes for the record. My apologies for being a little bit tardy. I have 3 bills over here, 3 different committees, and we were a little late getting off the floor, but I so appreciate your indulgence and the opportunity to present to you this afternoon. Senate Bill 828. I already went over that. It was a pleasure that I introduced 828, an implementation bill to construct the foundation necessary to fulfill the promise of the Time to Care Act of 2022, which this legislative body passed last session. As my testimony today, Mr. Chairman, I'd like to go over some of the amendments that we adopted in the Senate Finance Committee. The first amendment replaces the definition of wages on page 5 through 6. The original definition included fringe benefits, which didn't make sense for this purpose, i.e. some shouldn't receive wage replacement based on their health insurance, securing leave, country club membership, etc. The second amendment extends deadlines for the Department of Labor to notify employers of the changes in the status of an application from 3 to 5 days per the department's request. This was actually, the Department of Labor testified in our hearing and asked for this change to give 5 days as opposed to 3. And you could find this on page 7. The chamber seemed to agree with this in their written testimony. Another amendment struck the language altering what constitute a serious health condition. The resulting language is the language that passed last year. This could be found on pages 8, 15 through 16. Another change was we adjusted the language about who signs the benefits per the treasurer's request. That could be found on page 11. Extends the implementation deadline by 1 year to ensure the Department of Labor has time to set up the program. That change could be found on pages 11 through 13 and 20. That was, again, requested by the Department of Labor, who will be responsible for administering this. Also, some of our stakeholders also expressed an interest in extending the deadline. We added a contribution cap of 1.2%. This was a compromise based off of some negotiations with some of our stakeholders. That could be found on page 12. We also, the bill states that the contribution rate should be applied to all wages up to the Social Security cap. That should be found on page 12. This is not new language. It was moved from a different section that passed last year. We also set the contribution rate at 50-50. This actually matched the House bill as it was introduced before this body, and that could be found on page 13. Clarifies the process of Medicaid providers to receive reimbursement for employer contributions on pages 14 through 15. Removes the requirement that the state pay the contribution rate for employees making less than $15 an hour, since collections will begin after the minimum wage reaches $15 an hour. I think you guys just negotiated that with Miles, who spoke just before me. That could be found on page 14. Clarifies the overlap of FMLA and FMLI leave. Reinstates struck language that passed last year and clarifies new language. That's on page 17. Remove back of the bill language that is no longer necessary due to the extended timeline. That's on pages 24 through 25. Mr. Chairman, those are the changes that we made as a result of the deliberations in Senate Finance and the Senate and the bill before you. And with that, I would ask that we have a favorable report for Senate Bill 828 with the enumerated amendments. With that, I'll turn it over to Reagan Vaughn, if that's the chair's pleasure.
I was going to say, if you guys have any questions, don't wait until it's Erica's turn to answer them. She said, ask the questions if you have some, guys.
Thank you, Mr. Chair. Am I on? Oh, okay. Okay, after I heard all of those amendments, changes, and all that stuff that you just said, now what does this bill do?
Yes, ma'am. Right. So last year, as you know, Delegate Turner, we set up the framework for paid family leave. Okay. Since last time when we met, when we passed it, this actually sets up the framework for implementation. We've learned a lot in the last year since we set up the program. I think in part of the testimony that was provided both here in the House as well as in the Senate, there was some questions about, what we could actually achieve. There was a study that was done in the interim that made many of these recommendations. The bill before us incorporate many of the recommendations in order to make sure that this can be implemented and sustainable. Yes, ma'am. Thank you so very much.
Thank you, Senator, for this bill. I was proud to support it last year. My question is, we've had some issues with some rollouts in terms of the Maryland Health Exchange and the Beacon website. Have you gotten any assurances from the Labor Secretary that the rollout or implementation of this will, not have any issues?
One of the reasons why we delayed the implementation date was because of the feedback that was provided from the Department of Labor. As you know, excuse me, as you know, it was only just like less than probably a month or two ago that we confirmed the new labor secretary. She's very excited about this opportunity, but has asked the legislature to provide additional time so that we get it right and make sure that this is a product that the General Assembly could be proud of here in the state and that we're able to implement it.
Thank you.
Yes, sir. Thank you.
Thank you, Mr. Chair, and thank you, Senator, for introducing my cross-file bill.
Thank you.
I'm really honored to work with you on this. So besides, I'm just trying to make sure I understand all of the Senate amendments. Besides the cap, which is 1.2, did you just say at the beginning that we are now changing the notification provision from the 3 days to 5 days now?
Correct.
So upon application for benefits, the Department of Labor will have 5 days to notify the employer?
Correct.
Okay, regardless of the status of denial or approval?
Correct.
Okay,
Yes, ma'am.
thank you.
And that was at the request of the Labor Department, recognizing, and it's nothing to say that they won't have it prior to.
Okay.
They just wanted the accommodation to make sure it was 5 days.
Thank you.
Yes.
I believe that concludes all the questions for this panel. Thank you guys very much. We have
we're
several.
done? Thank you, Mr. Chairman. Appreciate the opportunity to present.
We have Bill George, Andrew Fulgenetti. Secretary Wu is not here, correct? That's fine. Michael Halloran. Go ahead, Andrew.
Thank you, Mr. Chairman. Andrew Fulgenetti, for the record, with the Department of Labor. I just signed up in case there were specific technical questions, but I'm not going to retestify if you guys have heard my testimony.
We appreciate you. Sir?
Good afternoon, Chair and members of the committee. Bill George with the Maryland Municipal League. I will follow my colleague's lead and reiterate our support of the Senate bill as amended. Happy to answer any questions. Thank you.
Okay, Mike, pressure's on, buddy.
Yeah. I wish I could be as succinct. First off, happy opening day to all those that are celebrating. For the record, my name is Mike O'Halloran, here on behalf of NFIB in Maryland. We still do have concerns with Senate Bill 828 and the amendments that the Senate made to the bill. I would certainly direct you to our written testimony, but if I could use this very, very brief moment to highlight one particular issue that small businesses continue to have. If you'll notice that in current law, the requirement is that an employee must exhaust all of their employer-provided leave before taking advantage of this benefit. Well, what the Senate bill attempts to do is flip that and leave that completely at the discretion of the employee. I would suggest, as my written comments allude to, that there's a way to split the difference here, and that would, in essence, provide predictability for employers and employees. And the idea here is to allow an employer, if they choose, to set a policy that requires employees to exhaust their paid time off, or come up with some sort of policy that can allow an employee to essentially make themselves whole. Whereas, again, current law requires it. Our suggestion is that you would allow an employer to set this policy. Again, there are other suggestions that we have in our written testimony, but I don't want to take up any more of the time. It's a beautiful day for baseball. So with that, I will conclude my comments. Thank you.
Thank you very much. I believe that, seeing no questions, I believe that concludes. Wait.
Thank you, Mr. Chair, and thank you for your brief testimony. So that suggestion that you just made, how far did you get with that, and as far as additional conversation and or feedback?
Well, well, put it to you this way, Delegate. The suggestion has been made. The suggestion has been out there. The Senate chose, it would seem, not to adhere to that, but that is why we're lucky it's not Nebraska, and there are two chambers instead of just one. So certainly, looking to the wisdom of the of the House to include this.
Sure, but I guess to take it a little further, what was the justification as to why?
As to why they did not include it?
Sure, just what was the concerns? I guess that's all I'm interested in knowing, what were the concerns
Sure.
behind that?
Well, the concern with, the current concern from an employer's
Right, I
standpoint
get
with the
your
current
point,
posture.
but I'm just saying what you've interpreted as a result of putting that suggestion out there, and just what is the restriction, or how would that hinder the employer? Does that make sense?
Correct. So the issue with the way that the bill is currently is that frankly, it's unpredictable and unbalanced for an employer. I'll give you an example. Say, delegate, you come to me, you work for a company that I have, you're an employee, and you say, hey, look, I want to take advantage of this claim, but I also want to use some of my paid time off to make up the difference. Okay, great. But another employee comes back and says, you know what, I want to preserve all my paid time off, for whenever. As an employer, again, for smaller employers in particular, this creates a very unbalanced, unpredictable program that they now have to manage. Whereas the suggestion of that be an employer they're not required to, but can set a policy that employees, if you have paid time off, you are required to use that in conjunction or ahead of time before you use paid time off. It's not treading new ground, because that's the current law right now, is that an employer would be required to exhaust all paid time off. We're not suggesting we keep that. Instead, we allow some flexibility.
Okay, thank you. Thank you for additional.
And when you say current law, you mean the law that isn't really in effect yet?
Correct. I mean,
okay, I just want to make sure. And again, mind you, I'm not agreeing or disagreeing with you. I'm just,
right.
You keep saying the word current law. I'm like, well, it's not really taking effect yet. That's why we, have this discussion. But all right.
Thank you, Mr. Chair.
I don't see any other questions. Thank you guys very much for your time. I believe that concludes the hearings for today, but don't go anywhere, guys, because we have voting session. Thank you very much.